Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel. Law offices of Cross & Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of domestic violence under the influence of alcohol. Let's see here. One night, I arrived home and my wife began to insult me and wanted to hit me. Okay, but did she actually hit you? Let's see. I pushed her and my son saw when she fell. He then called the police. Well, first of all, your wife could say bad words to you, insult you, but that's not a crime unless she's threatening your life. It says right here she wanted to hit you. Okay, but did she in fact hit you? The reason is because she wasn't hitting you. She wasn't in the process of hitting you. You didn't have the right to use any kind of physical force against her. Now, if she was in the process of hitting you, you do have the right to use physical force, but you have the right to use the minimum physical force necessary to avoid that you suffer additional harm. Now, let's say your wife hit you, but then she kept her distance and ran off. You don't have the right to chase her to hit her back. She could be charged with domestic violence, and that's it, but you can't hit her back. The law does not allow for payback. The law does not allow for revenge. Now, if somebody's in the process of hitting you, you can hit them, but just to keep them off of you, to keep them from hitting you more. Now, the problem is you push her, your son is right there in the room, sees her falling, get hurt. She calls the police, said, yeah, daddy pushed mommy and she fell. Well, then you're going to be charged with at least a violation of Penal Code Section 243, parentheses E, parentheses 1, which is a misdemeanor that carries up to 1 year in county jail. If the alleged victim suffered any kind of visible injury, any bruises, any cuts, any marks, any welts, then you're going to be charged with a felony under Penal Code Section 273.5, which carries up to 4 years state prison. Now, I also need to know, how old was your son, the one who called the police? Was he under 12? Was he a kid that really needed your care? That the reason is because in a situation like that, you could also be charged with cruelty to children due to causing the child's psychological harm based on the fact that you pushed his mother in his presence. Under Penal Code Section 273A, parentheses A, that's a felony that carries up to 6 years state prison. So we need a few more facts in this case, but it seems to me that you may have a potential defense for self-defense, but self-defense is a very fine line. There's a very fine line between self-defense and revenge or payback. It's a very fine line, and you don't want to cross that line. One is full exoneration. The other one could potentially land you in state prison. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. But if you've been accused of a crime and need representation in court, call us now for free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.